Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
And if you don't, I don't think you do, because I think historically that wasn't the case. So how do you?
In the Senate chamber, Senator John Kennedy locked horns with a constitutional law professor in a tense back and forth over one of the most fundamental questions in American law. How should we interpret the Constitution? This exchange covered originalism, racial equality, and even the limits of legislative history. Let's break it down. Kennedy began by pressing the professor on the idea of original public meaning. That phrase means interpreting the Constitution based on how ordinary people understood it at the time it became law. The professor agreed, but this definition opened the door to one of the most controversial cases in American history, Brown versus Board of Education.
Professor, congratulations. I believe you testified that you think the Constitution should be interpreted according to its original public meaning. Is that right?
yes, Senator.
What does original public meaning mean?
Yes, Senator. So the original part of that phrase refers to the fact that when we look at interpreting a text, we want to interpret it at the time it was.
Professor, look me in the eye and just answer my question. What does original public meaning mean?
It means the meaning that the text as it was understood by the public at the time it became law.
Okay. So you think Brown v. Board of Education was incorrectly decided?
Well, Senator, I think Brown versus Board of Education was correctly decided. Scholars who have looked at the original meaning of phrases at that time and the reasoning in that case sometimes question the reasoning of the case.
How many people in the United States of America at the time the Constitution was drafted do you think supported racial integration of schools? You think that was a majority view, do you?
Well, Senator, at the time.
But first, Professor, do you think that was a majority view? Do you think most Americans at the time the Constitution was drafted supported integration of public schools, racial integration?
Well, Senator, I don't know as a sociological matter what percentage of people thought what at that time. I should point out that when we got to Brown versus Board of Education, of course, there had been several fundamental amendments to the.
But isn't that inconsistent with your statement that you have to interpret it according to original public meaning?
Well, what about the 14th Amendment and the 13th Amendment and the 15th Amendment? So original public meaning would mean with those. Well, that would mean we would interpret those amendments and those protections with the understanding of the text and structure at the time those amendments were ratified, which is different, of course, in the 19th century.
Let's go back to Brown v. Board. Look, I think Brown v. Board was correctly decided, and I suspect you do too. But if you say we interpret the Constitution according to the way that people at that time understood it, do you really think that people at that time in America supported racially integrated schools? Do you really believe that?
Well, Senator, I think at the time of the ratification of the 13th, 14th Amendment, and 15th, all which have.
But do you think people at that time supported integrated schools?
Well, Senator, on that particular question, I don't know it as a policy matter whether they were thinking about that particular issue. I think they certainly understood that the 14th Amendment, for which a massive part of this country essentially lost lives fighting the Civil War, certainly understood it to require racial equality.
You're not answering my question. I'm just trying to understand how you think. It's very easy to say, we interpret the Constitution according to its original public meaning, which as I appreciate your testimony, means the way people who read the Constitution at that time interpreted it. Is that right?
Yes, Senator.
Okay. Do you think that most people at that time looked at the United States Constitution and said, well, here it is, big as Dallas, racially integrated schools are required? Do you really believe that?
Senator, I don't know, but
and if you don't, I don't think you do, because I think Historically, that wasn't the case.
well-
So how do you square that with the holding of Brown v. Board?
Well, I guess what I'm trying to say is I think there are several steps in between that have not come up yet in our conversation, which is that you look at the text and structure, which of the 13th, 14th, and 15th Amendments clearly is requiring racial equality. And then over time, that has to be applied to different questions as they arise in context. So if the requirement is that all races be treated equally under the law, and the evidence shows that segregated schools is not doing that, then the requirement could be applied to integrate schools.
When you interpret a statute, you talked about interpreting it according to its plain meaning. What if the statute is ambiguous?
Well, Senator, if the statute
What do you
were-
do if it's ambiguous?
if it's ambiguous on the particular question coming before the court, I start with that phrase, but I also look at the context of surrounding provisions.
No, how I understand you define ambiguity as the language plus the surrounding language.
Yes.
I get that part. How ambiguous does it have to be? 51% ambiguous or just a little bit ambiguous?
So I have to say, I would use the same approach essentially in all cases, regardless of the ambiguity, because I would always start with the text, move to the surrounding provisions with the aim of fully understanding what Congress and the President had enacted. And only at that
Professor,
point.
I'm going to run out of time. With respect, answer my question.
Well,
Okay, you're giving me professor talk. How ambiguous does it have to be?
I mean, I think under the Supreme Court's recent precedent in Chevron, it underscored that the court can never just rest and say it's ambiguous. The court has to come up with an answer.
Yeah.
So
So
I
why
would,
don't you just look at legislative history?
well, you can't look at legislative history of statements one by one because
Why
the
not?
individual
Why not?
intent. Well, Senator, with respect, because this body has its role in our system as an institution, not one by one. So your personal understanding of the law doesn't
This will
matter.
be my last question, I'm sorry. Well, Coons went way over. So you're telling me that it doesn't help you at all to go through and look at the congressional record or read the committee reports or any of that? You don't think that's helpful in interpreting what a statute means?
It depends on the way in which it's being read. If it gives helpful statutory history, if it helps to refer to other portions of context, sure, but not to give it legally binding impact in and of itself. I would always be looking at a broad range of sources and use each of these statements as just one piece of evidence about what people understood the statute to mean at the time. So no, I would never take a piece of legislative history in isolation and give it legal impact.
Thank you, Madam Chair.
Thank you.
Kennedy challenged the professor directly. If the Constitution must be read by its original public meaning, then how do you reconcile that with the decision that outlawed segregated schools? At the time of the Constitution's drafting, the majority of Americans did not support racial integration. The professor pushed back, saying Brown was rightly decided, and pointed to the 13th, 14th, and 15th Amendments as evidence that equality was written into the nation's legal foundation. The senator pressed harder, questioning whether Americans in the 19th century truly believed in integrated schools. The professor admitted uncertainty, but emphasized that the principles of equality enshrined in those amendments must be applied across time. In other words, even if the public wasn't thinking about schools in 1868, the legal requirement of equal treatment had to evolve with new contexts. Kennedy shifted the debate from constitutional law to statutory interpretation. What happens, he asked, when a statute is ambiguous? The professor replied that judges must begin with the text itself, then move to surrounding provisions for context, never stopping simply because language is unclear. Kennedy demanded a clearer answer. How ambiguous is ambiguous? The professor insisted courts must always reach a decision, sometimes referencing cases like Chevron to back up his point. The senator then asked why not just rely on legislative history statements, records, or committee reports from Congress. The professor was cautious, explaining that such records can provide helpful context but should never have binding legal authority. For him, the focus remained on the enacted text, with history serving only as one piece of the puzzle. If you're following this breakdown and enjoy in-depth coverage of political debates and legal philosophy, make sure you hit that subscribe button right now so you don't miss the next analysis. This fiery exchange between Senator Kennedy and the professor wasn't just about one case or one doctrine. It captured the broader struggle in American law. Should we be bound by the original meaning of the Constitution, or must those principles adapt to modern challenges? On one side, a senator demanding clarity and tradition. On the other, a professor defending context, evolution, and the enduring principle of equality. The debate over America's founding document is far from settled, and this hearing proves it.